Be ready. 5 seconds.
All these three writ applications, having filed on identical facts with the same cause of action as with regard to a challenge to the demand notice for payment of price of custom milled rice CMR in lieu of paddy received by the petitioners pursuant to a written separate agreement entered between the petitioners and the Bihar State Food Civil Supplies Corporation Limited, hereinafter referred to as the corporation, have been heard together and are being disposed of by this common judgment. Learned counsel for the petitioners in all these three cases have sought to primarily assail the demand notice on the ground that prior to issuance of the demand notice, no notice and or opportunity of hearing was given to the petitioners. It has further been submitted by the learned counsel for the petitioners that in these three cases, though it is true that the petitioners had entered into an agreement with the corporation for lifting the paddy and also supply of CMR in lieu of paddy, but when the quality of the paddy was found atrocious and the CMR prepared by them was not being lifted by the authorities of the corporation, the petitioners cannot be held to be liable for payment of any amount, much less the impugned demand notice issued by the corporation, especially when their action also in respect to admitted supply of CMR, either in respect of milling charges or transportation charges, have not been settled and paid to them as yet. Mr. R. S. Pradhan, learned senior counsel for the corporation, on the other hand, has submitted that all the three petitioners are bound by inter-party agreement, wherein they had not only undertaken to return CMR in lieu of paddy received by them, but also to compensate the corporation if CMR was not delivered to the corporation in terms of the agreement. Mr. Pradhan, in this regard, also submits that a writ petition of the present nature will not be maintainable for enforcing the terms and conditions of the agreement on the grounds of its being non-statutory. In the considered opinion of this court, all such writ applications, including the present three of them, in which only demand notices have been questioned by the individual rice mill, are not maintainable in view of the law laid down by the apex court in the case of Radha Krishna Agrawal Supra. With the aforementioned observation and directions, these writ applications are disposed of.